Hello, and welcome to the Courtney Turner podcast. My guest today is Don Grande. He's an attorney. He is running the True North Public Policy, which is fighting the great taking. We have talked a little bit about the great taking before, but we're going to get a little bit deeper into it with him. And he's also recently been to my state, and he was fighting against some of the land grabs that were going on here. We know we've covered this quite a bit. My presentations on the natural asset companies that I did for the legislators that I'm told was the result of Frank Nicely being primaried out, unfortunately, because he was a true champion in our state. So, as always, they're always rebranding. They don't rest, unfortunately. So we really need to stay vigilant and be aware of what these plans are. Even when we think we have little wins, that doesn't mean we ignore the wins and be demoralized. They like that. But we still need to stay vigilant and be really aware of what it is that they are trying to do. So without further ado, I know we have limited time today. I'm so looking forward to this discussion. Don Grande, how are you doing today?
I'm doing great. Doing great, Courtney. Thanks for having me on.
Thanks so much for being here. So, I'd love to get your a little bit of a background on what the True North policy is. How did you get involved with them, and what is the great taking from your perspective?
That's
Very
a good
simple
question,
questions.
and it's all related.
Yeah.
So I learned about the Great Taking and David Webb in December of 2023. I wasn't aware of David Webb. I wasn't aware of the Great Taking, even though I work with the UCC, the Uniform Commercial Code. So I downloaded his book, which is available on our website for free as a PDF download. And I read it and I watched his video and I thought he was crazy. Said he's absolutely nuts. And so I spent the next 2 weeks without very much sleep, running down all the sites that he has in his material and finding some resources of my own, and it checked out 100%. So at that point, this was like New Year's time, 2024, legislative sessions in states were already geared up. In some states, it was already past the bill filing deadline. But my wife is a former state legislator for 17 years and now works with Pro Family Legislative Network out of Dallas, part of David and Tim Barton's Wall Builders. And so I brought the issue to them and said, this is a family issue. They're taking assets, or your assets are at risk. And so the Bartons got a call with them, and they had a few questions, good questions, and they jumped on. So we got the bill language out to South Dakota and Tennessee in 23. So what happens there is that it requires quite a bit of meeting with lawmakers because it's a topic that's out of the blue. They don't have a clue what we're talking about with the Uniform Commercial Code. Eyes glaze over. So it certainly in most states is considered lobbying when I'm down there talking to them, even though I'm not whining and dining at all. I'm just offering information. So my wife and I formed True North Public Policy LLC to be our lobbying arm and informational arm. So that was the reason we did it, because Pro Family Legislative Network Wall Builders is a 501c3. They can't really get involved in legislation per se. So we went ahead and formed True North Public Policy to push this forward. And that's what we've been doing legislatively in about 15 or 20 states so far, but not having much luck. The bank lobby and the Uniform Commercial or the Uniform Law Commission are very powerful. And when we were down in your great state just a few months ago, it was a very icy reception compared to what we got in 2023. The lobbyists were well aware of what we were doing, and they had pretty much killed the bill before it even got a hearing. So that was unfortunate. So basically, just to jump back to your main question, the Great Taking. So if you're familiar with David Webb's book, The Great Taking, he goes into a great detail about the financial system as it's structured today. And the underpinning, the result is that the stocks and bonds mutual funds, IRA in your IRA or 401k that people think they own, they don't actually own anymore. They have the appearance of ownership, and that comes from a state law change in the mid 90s. It's actually the 1994 UCC Article 8 revision, the full title, but it was approved by all 50 states over the next 5 or 6 years. And what that does, it significantly changes what the concept of property rights are when it comes to your stocks and bonds. Dealing with securities. Securities are stocks and bonds, mutual funds, ETFs, anything that you hold in an account with your broker is not really truly yours like you thought it is. In the old days, people used to hold stock certificates. They had paper certificate, and when it was in your hand, you owned it, you controlled it. You don't own and control what's in your account at your brokerage firm anymore. And I can get into specifics about why that is, but in a nutshell, that's what this is. It's the great taking that in the event of a significant financial collapse, which could be any day, most of the stocks and bonds you think you have in your retirement account are going to be gone, and there's nothing you can do about it.
Wow. Could you explain a little bit about why that is, that you don't officially own it? Yeah.
Yeah, sure. So what the 1994, let me step back. So these uniform laws are promulgated by what's called the Uniform Law Commission. It's a group of people, it's all attorneys, which is probably, red flag number one, from all 50 states, but it's really driven by a small group of special interest attorneys. And in the 1987 stock market crash, which took down Drexel Burnham Lambert at the time, they were the junk bond people. It really shook the folks on Wall Street because they were worried about collateral and liquidity. So they started working on that. And the American Bar Association went to Congress to do some things, but the Uniform Law Commission thought they had a better approach, and that was to revise Article 8 of the Uniform Commercial Code. Article 8 deals with securities, stocks and bonds, and so they set about revising that, and essentially it was a total rewrite. They deleted the existing Article 8 and put in a brand new one, and they introduced some new words, some new concepts. One of them was a security entitlement. So that when you call up your broker and say you want to buy 100 shares of Apple, and your broker goes out there, debits your account, takes the cash out, and goes out and buys 100 shares of Apple and shows it in your account, you think you own 100 shares of Apple. What you actually have is a security entitlement that's kind of like a contract with your broker that the broker promises to pass through the dividends and everything to you. So they just conjured up this idea of a security entitlement. It's out of the blue. So it's not a true full property interest because other people have rights to that security entitlement. And so the upshot of Article 8, the whole purpose of it is to protect the big banks, the too big to fail banks. And so what happens there is there's provisions throughout Article 8, and then there's, federal regulations that say that brokers can't use their clients' stocks as collateral. It's against the law, but on the odd chance that somebody on Wall Street might actually break the law, they have to put some provisions in there to protect the big banks in case of that. So that's where it comes in, is that and I try not to use too much jargon on this, but it's Article 8, Section 8511. And what that does is carves out two exceptions to the general rule that the stocks and bonds in your account are yours. It says that, and then it says except. And then there are two exceptions there that carve that out and say that if a securities intermediary, your broker or a custodian, pledged your assets as security for a loan and then became insolvent, the big banks are the ones protected, can take that collateral, and that's your stock. It's gone. And the second exception is for a clearing corporation like DTC. So any lenders to DTC, if DTC goes under and it's not very well capitalized, the banks that lend to DTC will get those securities and you won't. And when you talk about that, when David Webb or I, mention that to legislators or anyone, they think that's kind of crazy. That doesn't make any sense. But it's not just us saying it. That's the thing that I wanted to try to get out in Tennessee when I was there the last time, is that if you pull up your Tennessee code and you go to the UCC section, UCC Article 8, Section 511, and you look at what's called the official comments. So they've got comments in there to explain what 8511 means, and it says it right in there. I mean, it's not just me saying it. It's not just David Webb. Your legislators, when they pass this law, is right in the annotated statute, and it comes straight from the drafting committee. So what they're saying is that even though there's these protections out there, they always say the SEC protects investors, you got the SIPC and all that sort of stuff. And there's rules that these Wall Street folks aren't supposed to use, client assets as collateral. But the drafting committee asked themselves, what if they do? What if they break the law? Mm-hmm. And if they said, in that case, we want to make sure the banks are protected. So that's why they put those two exceptions in there. It's just easy as that. I don't know if that's easy.
Right. I'm not sure it's super easy, but the big takeaway is that they're protecting the banks, but they're not protecting you. So it's your Correct. Asset. And so where's the protection for the person who thinks they own these assets?
Well, that's a good question. And they sort of play this trade-off game. So the UCC is state law, and the UCC Article 8 does include a statement that says, your broker can't use your stocks as collateral for the broker's loan without your permission. Mm-hmm. And the problem is that your broker doesn't hold the stock either. It's at a custodian at a higher level, actually held ultimately at Depository Trust Corp. So there are all these levels of intermediaries in there, and any one of them has a claim to your security entitlement as well. And if any one of those custodians or your broker illegally uses your assets, your stocks and bonds, pledges them as collateral, they're gone. And so the drafters of this uniform law change, it's called the drafting committee, it's an official drafting committee. They said it right in there that there are other regulations that adequately protect investors. And they refer to things like the Securities and Exchange Commission. There are some federal laws, the 1934 Securities Act, Investor Protection Act. Again, they're laws that prohibit, wrongdoing. Mm-hmm. But there's there's laws prohibit, murder, and still people still murder. So, on the off chance that somebody on Wall Street might try to cut the corner or something, they're relying on these other protections. And, if anybody follows what's going on as of late, really since the 2007-8 financial crisis, the SEC idea that they're the watchdog out there, they're not doing much. It's a revolving door between them and Wall Street, essentially. Right. So you can't expect much protection there. It's kind of funny. The opponents of our bill would say, well, the investor is protected by SIPC. It's like FDIC insurance, but it's for your investment account. And that's an interesting thing, because first they say this can't happen, the investor can't lose anything, but then they say if they do, we've got insurance coverage. So it's not, doesn't make any sense. But the bigger problem is that the insurance coverage may not be there for you anyway, for a couple of reasons. One is that the SIPC doesn't cover insurance or securities contracts or investment contracts, and the security entitlement concept is more of a contract than an actual security. So it's not clear to me whether SIPC coverage will even apply for the individual investors. And the SIPC is very thinly capitalized. It's really intended to handle one broker dealer failure at a time. What David Webb's talking about here is a systemic financial collapse where multiple entities go under and the SIPC just has no money to cover you. Will Washington print some more money and bail everybody out? Well, probably not us, but the banks are going to get bailed out again.
Right. All right. Well, I have two questions from that. One is, there anything that can be done? I'm guessing that's what you were trying to do with these various states. That's the first question. And then my second question, answer in any order, whatever. But the second question is, do you think that they will intentionally try to collapse the financial system to take?
I'll answer the second one first. I don't think they're going to try to intentionally collapse it. I think they could anytime if they wanted to.
Right.
They could use any number of catalysts or make-believe catalysts to trigger it. But the thing that I think is helping us a little bit is that they're greedy enough that they want to get a few more things in place before they actually trigger it. Now, if we ever got traction at the state level and we're getting some changes made that protected investors, then that might move up their timeline a little bit, which wouldn't be a good outcome. But I think there's related issues in there regarding real estate. You mentioned the NACs.
Yep.
The real world assets that they're trying to digitize.
Yep.
Some of the changes they made to the Uniform Commercial Code, including the one we're talking about and a later one, in my mind, they're setting it up so that once they have the tokenized real world assets, they're all going to be on the same system. And if you participate in that with your real estate, it's gone too. And so I think that carrot's out there for them, and they can taste it. So I don't think they want to trigger it yet. They want to keep it going. Now, first question, what can be done? Well, a couple of things. One, it started out, it was basically my wife, who was a policy director for Pro-Family Legislative Network, myself, David Webb, a couple of Betty's colleagues, 5 of us basically going out there against the bank lobbying cabal and the uniform commercial cult, as I call it. And so we're just trying to completely fix the Uniform Commercial Code Article 8 is way too heavy of a lift for a small group of people because it's really complicated. So what we tried to do was just go in there and remove those 2 exceptions. That's basically all this bill does. It's a real simple bill. It just removes the exceptions that give a bank or a lender, a too big to fail bank, priority over your assets. Mm-hmm. Just take them out. Seemed pretty simple. But obviously the bank lobby doesn't want that, and we haven't had any success. Part of the reason, I think, is public awareness still isn't quite where it needs to be. I kind of go back to the ESG battles we had back in 22 and 23. Nobody even knew how to spell ESG at the time, so we couldn't get anything going. But that picked up very quickly in public mind. So I think that would help. I get a lot of questions from individuals, what can I do?
Yeah.
And I can't give legal advice. I can't give investment advice. But the problem is it's very limited. Most stocks are still available in paper certificate form. So you can request from your broker, when you buy 100 shares of Apple, you can request a stock certificate, and they won't like it. And they'll charge you some more for it, but they'll mail it to you. It's a hassle because then if you want to sell it, you got to endorse the stock power and send it back and do all that sort of thing. But then if you've got that paper certificate in your hand, you own it, and nobody can use it for collateral other than you. The problem with that is and that's an excuse or an objection that was offered against our efforts by supporters of the current law. They said, well, people can just order paper certificates. Yes, but it's really limited. And like I said, most companies out there, the big ones that are trading on the New York Stock Exchange, still offer it. Bonds aren't really available too much anymore in paper form like they were back when I started in this business. Mutual funds, some of them have certificates, most don't. Exchange traded funds do all are digital only. So that if you have exchange traded funds, you can't take a physical form. But the bigger issue that for the small investor is that most of their stocks and bonds are held in their IRA or 401k, and you can't have physical custody of qualified plan assets or IRA assets. It's prohibited by law. So, and so your biggest asset out there, the one you're relying on in your IRA or 401k, you have no option around this thing until we get this law fixed.
Wow. That's huge, because I think a lot of people are very concerned about Social Security not being there, right?
Yeah.
So a lot of people have really tried to invest in 401k or some sort of IRA type protection for their retirement. And that's pretty horrifying to think that, especially people who, put away routinely, every month or whatever, that they're building that and they're making sacrifices in the short term. So hoping that they're making some sort of provisions for their future. So that's
and that's the we're not having a lot of success so far on the legislative front. But what David and I have been talking about since your state's defeat of this is that we really want to just push public awareness on this, because that's the thing that gets me is that this is the epitome. It's the definition of too big to fail, and they just want to use your assets instead of printing more, having Congress come through. And we've never had a national debate over too big to fail. I mean, maybe there's a reason. They say that it'll hurt all of us if these big banks go under. Well, maybe, but we haven't had nobody's voted on that. People have the people I talk to when I say this, they don't have the same impression of too big to fail. That it's worth them giving up their retirement assets, without their permission and without their knowledge. So that's my thing, is that I just want people to be aware. Podcasts like this are excellent to get the word out to people. At first, I know it's overwhelming, a lot of information out there. It can get a little jargony. The information on we've got a Substack that's dedicated to this, and the pieces we put on there are a little more digestible, I think, and I try to really make them in without all the legalese and UCC jargon. So that's a good place to go, just awareness, because when you first hear this, you think that this absolutely can't happen. It's crazy. So the interesting thing is that, one of the tactics they used against us this year in South Dakota, Wyoming, North Dakota, Tennessee, was that, David and I weren't doing this right. If we had a problem with the Uniform Law Commission, we should have gone to the Uniform Law Commission, because they had no idea about this. That's what they said, right? Well, they knew about it. They've known about it. They did it on purpose. And in 2016, there was an article in American Banker talking about it in 2016. In 2020, New York Law Journal, in December of 2024, the New York Law Journal had an article about it, and they know about it. The American Bar Association set up a 4-year task force with one of the masterminds of the 1994 change. Just ended in December. Crickets. They're not going to do anything. The banks that were behind it and the financial institutions, after the study or after the task force, found no compelling economic reason to make any changes at this time. So,
wow.
And that's not going to change unless people really get aware of this and, bring some heat.
Yeah, no, absolutely. When you're talking about the national debate about the big banks being too big to fail, I think part of the problem, and forgive me, I'm not super versed in the financial sector, so my perspective might be off, but I think that there's collusion, right? Didn't back in 2018 Trump make I believe he made BlackRock like the managers essentially of the Treasury. Which, I mean, not that the Federal Reserve is even constitutional to begin with. That's a whole nother conversation.
Whole different thing, yeah.
Right. But to me, that seems like a major conflict of interest. And so what are your thoughts on that and how that's playing a role?
Well, yeah, I mean, it plays a fundamental role in this. The BlackRocks are the big dogs on the block, and they carry a lot of weight. And
they're obviously to State Street and Vanguard, and it's
absolutely, So. They're all in the same. But BlackRock and the spokesman Larry Fink, which is a perfect name. I mean, he's all into this tokenization of real world assets.
Yep.
He wants to tokenize everything, and so it's all part of the same thing, and that's why the big banks are still, running. Obviously, they own and run the Fed, so the banks are in charge and they're looking out for themselves. Larry Fink's involved, and it's all interconnected, and that's why it gets to be overwhelming for people, I think, because there's so much coming at us. We've got,
I think, intentionally.
Intentionally. Absolutely. Agenda 2030, 30 by 30 land grab, it's all the same. And people say, what can I do? Yeah. And so that's understandable. But I think definitely the folks in Washington, even the ones that are kind of on our side, don't really fully understand how the deck is stacked against us. And the assertions that the little investor is protected. I mean, they do not. It's a house of cards. You can take those arguments apart in seconds. There's nothing there, but it's a talking point for them so they can pat themselves on the back and move on, knowing full well that at the end of the day, BlackRock and the banks are going to be sitting just fine. And that's supposedly for our own good. Which, all these things are always for our own good, right?
Of course, that's how they sell it. Yeah, it's for your own good. Well, I think it is really important for people to understand that they could, and you had mentioned this, they could just print money, right? That I'm not condoning that, but that's a reality. They can just do that at any time. What they want, it's not that they need our investors' money. I think it's something like 10% of the United States is, invested in 93% of the stock market. So, most people don't have the luxury of being in the market. So, they're concerned about their day-to-day bills and the gas prices of food and, and more of the basic kinds of things. However, that's not to say that the markets aren't important. I mean, that's and a lot of people, especially with the 401ks and the IRAs, but even just portfolios, people are putting that aside thinking, and a lot of people are making sacrifices again in the short term because they're thinking that's their provision. They're thinking, okay, I'm putting this away for a rainy day and hoping that it'll grow more than any, job I could get would allow for. So, it is definitely important. But I think that the key that people need to understand is that they want to enslave us in a way. And you keep bringing up the tokenization. And, the thing I keep saying is that they talk, one of the selling points of the tokenization, at least what I've heard, is they're saying, oh, well, this is so great for the little guy because you could own like fractional, assets. Like we could share assets on real estate and art and, all of these things. And I'm sitting here thinking, you'd think that in families you could share assets, but there's a reason that estate lawyers exist because that doesn't reality, right?
It gets messy.
Yeah, and you'd like to think it could be all warm fuzzy, but you think with complete strangers you're going to have fractional assets and that's going to just work out fine and dandy. But what it really does, it allows for them to completely surveil, control, and enslave the masses. I think that's really